Order, order. Welcome to the Northern Ireland Affairs Select Committee session on the operation of the Windsor Framework. And we have Dr. Kirsten Dunbar online. Could you introduce yourself, please, Kirsten?
Thank you. Good morning. I'm Dr. Kirsten Dunbar, and I'm currently President of the British Veterinary Association Northern Ireland branch.
Thank you very much. Now, in the absence of an agreed alternative solution, what is your current assessment of the impact of applying EU rules on veterinary medicines in Northern Ireland and the percentage of medicines at risk?
Okay, thank you. We have two main issues in relation to bringing medicines into Northern Ireland, and those relate to, firstly, to the need for batch testing within the EU, and secondly, for the marketing authorisation holder's address to be located in the EU. So for products produced in Great Britain, this means that batch testing in Great Britain and an address in an MAH, a marketing authorisation holder's address in GB, is not suitable. And also, in addition, the majority of our medicines actually are produced in the EU, but the traditional route for accessing Northern Ireland is via GB. They would come from EU to GB, warehoused there for further distribution across the UK and to the Republic of Ireland. However, anything that is being exported then from GB to Northern Ireland would need again to be rebatch tested within the EU.
And what specific effects would its application have on Northern Ireland's farming and agri-foods industries and for consumers?
So initially we thought that it could be up to 50% of the current veterinary medicines would be lost to Northern Ireland. Work has been ongoing, and that has estimated then to be reduced to around 30%. And recent insights now estimate a figure close to 10%. The problem is, and that's thought to be due to a number of companies now rerouting product from the EU through the Republic of Ireland rather than through GB, and some alternative products being identified to replace those currently used. The problem is not really the percentage. The problem is if there is a critical medicine. So it's about the type, the volumes used, and whether it is critical. So we had initially, thought that some vaccines may have been implicated. So vaccines for instance, salmonella and botulism, both essential in the Northern Ireland situation, and in salmonella's case, essential for both animal health and public health. Because of the nature of the commercial and confidence nature of the work ongoing, it's indicated that we're not going to have a problem with this, but we haven't actually had that confirmed or it been made public.
And have you been told when it might be made public?
No, we have been asking for a list. We still have no list of critical medicines that may be at risk, and we have been, I suppose, calling for that list and for some stakeholder engagement, public stakeholder information.
And so, that public stakeholder information, is there any reason? Is there any reason why that's not happening?
Well, I think it still is. I mean, a lot of businesses are is commercial in confidence. I'm not quite sure why we're not being supplied with those lists so that we can make plans.
So the discontinuation of certain veterinary medicines, how's that going to impact on cross-border trade with the Republic of Ireland? I mean, you did say about the rerouting of some of them.
Medicines that way, yeah.
Yeah. Do you see it having an impact on the cross-border trade with the Republic of Ireland?
I suppose that not so much the loss of the medicines, But obviously, animal health in Northern on the island of Ireland we're considered to be one sort of epidemiological unit. So, what happens in the north could affect the south. But I suppose it's the solutions that are put in place, because a number of, for example, I think this was the one that was illustrated in the press. A lot of milk is exported from Northern Ireland to the south of Ireland for onward processing and further export to the EU or to any other country. And therefore, the support certification has to be delivered by Northern Ireland to the south to say that it complies with EU rules. So it's whether the solutions put in place, the workarounds put in place to ensure that we can access critical veterinary medicines, comply with EU rules, or the EU is aware and approves of these, then those support certificates may not be able to be completed, and therefore that will have effect on trade. It may also have effect on trade in Northern Ireland products for to product of animal origin to GB, perhaps for onward export to the EU, or to even our own, or to third countries, or even our own Northern Ireland exports to third countries, where a number of certificates will actually have a clause in them saying the products are produced in compliance with EU vet medicine regulations.
Thank you, Kirsten. Simon Hall.
Thank you, Chairman. Good morning, Dr. Dunbar. Business obviously wants to sell its product, and many have demonstrated in recent times considerable agility in meeting the new tests and challenges. I just wonder if you could talk us through your understanding, please, of the adjustments which have already been made by the pharmaceutical industry itself to ensure continued supply of veterinary medicines in Northern Ireland next year.
I do believe that a number of them have rerouted product, as I said, so not delivering to GB for Northern Ireland and the Republic of Ireland, but directly to the Republic of Ireland. And I know that there is further work ongoing around how we can access veterinary medicines from outside the EU and GB with special import certificates.
Thank you for that. I just wonder, are you able to give us some indication as to, if you were to percentage it out, what's your sort of level of concerns about certain medicines, treatments from the pharmaceutical sector that won't be or wouldn't be available?
Well, I mean, yeah. So NOAA, which is the UK's National Office of Animal Health, estimated in April of this year that 10 to 15% of products could be withdrawn from the Northern Ireland market. A percentage of those then will be critical products. So that is no product that has an alternative that we can use. And as I said, it's not so much the percentage, but if there is one product that is critical and that we need in volume, could have a huge impact. So just, one product, one vaccine, if it was, for instance, the botulism vaccine, if we couldn't get that would have a severe impact on animal health within Northern Ireland.
But in terms of access to the usual medicines, if you will, that a vet will prescribe to a pet owner on a daily basis, where are we on that in sort of terms of percentages and figures?
I don't have any specific percentages on that, but I do know that some of the critical products, or the products that may not be supplied to Northern Ireland, are those for equines and for pets, domestic pets.
Okay, thank you.
Which is of great concern to horse and pet owners.
Yes, indeed. And it's your assessment, therefore, that there's no other legitimate route, I underscore the word legitimate, but legitimate route in order to secure access to these treatments?
There may be through special import certificates, but again, that we don't have that list of product, the critical list. We cannot really say anything at this point as to that, and that would be for perhaps VMD or DEFRA to answer.
Okay. And the responsibility for that certificate would rest with the veterinary surgeon to secure, or to the producer within the pharmaceutical sector?
Yeah, there are requirements for both the veterinary surgeon and for the wholesaler or the people who actually do the importation, and also for and then this is where it gets a little complicated, because the VMD, the Veterinary Medicines Directorate, is responsible for the administration of these SICs in the UK. However, I believe that will not be allowed in EU terms, and that we would need to have some kind of SIC system set up for Northern Ireland.
Okay, and is your assessment that there's an appetite for and preparedness to work towards a regime between producer and end user, the vet, in order to minimise, if you will, disruption to supply, notwithstanding the fact that there may be some degree of onerousness with regards to applying for the certificate?
Oh, absolutely. But it does, anything that includes extra time and effort, and also for the pharmaceutical companies, could add cost to veterinary medicines in Northern Ireland.
Okay. But is it your assessment, on the basis that where there's a will, there's a way, that if there is a need for a product, whatever the product might happen to be, that it would be available should need be there, and as long as whatever the certificate requirements are met?
Yeah, certainly. But again, we have to be cognizant of the fact that the EU would have to approve any, whatever system we have in place would have to be, recognised by the EU in that.
Yes.
To still comply with EU regulations and allow our, in terms of product of animal origin, in terms of export.
Okay, thank you very much.
Okay, Gavin Robinson.
Good morning, Dr. Dunbar. Thank you for joining us this morning. You're not a member of the Veterinary Medicines Working Group, isn't that right?
We are, yes.
You are a member?
The British Veterinary Association Northern Ireland branch does have a member at that meeting, and I attended the last meeting on the 4th of March.
And so, reflecting on what you've said this morning, are you outlining that you don't have information gleaned from that Veterinary Medicines Working Group, or that you're not in a position to share that information this morning?
We have some information gleaned, but we are under a confidentiality agreement on that. So we do have some information gleaned, but I personally have not seen a list of critical medicines at this stage. Okay.
If I put some things to you, would you tell me if they sound wildly inaccurate?
I can try.
Would it be right to say that there are 14 products now considered high risk?
I could not put an actual figure on that. I'm sorry, I don't have that recall.
And right to say that there would be about 60 products that would be considered at medium risk?
Again, there are products, high risk products, a small number. There are medium risk products, although we have been informed that for the majority of those, there is an alternative that could be used.
Yes. Are you aware of discussion around two potential options? One categorised as a critical products list that would receive the necessary animal health and welfare certificates from the Veterinary Medicines Director, and a second alternative solution that is described as a cascade model. Does that make any sense to you?
I am, yes, I am aware. And the cascade model is an EU model that is currently in place for medicines not produced for animals and often used in the pet world. Yeah.
That's right. And so that would envisage a vet diagnosing a problem, believing that they need a medicine, understanding that there is no alternative to that medicine, and then you cascade through a number of options,
Yes.
and then essentially on animal welfare grounds that medicine would be made available to that vet. Does that sounds about right?
That's correct, under a special import certificate.
Yes. Now, practically, do you as a veterinary association have concerns that in going through all of those steps, it may be that the medicine required by the vet just simply is not available, or the distributors don't have an ongoing supply because the individual circumstance hasn't arisen, and therefore the individual medicine hasn't been made available?
Yeah. All of those things could arise. Yes.
Well, so what is the discussion taking place at the moment as to how, if this is being purported as a solution,
purported,
how do you
if
get
it is
around
a solution, that there is a simplified system put in place. Instead of having to put a lot of information into your application form, that it will be simplified in some way for drop-down menus and for the most commonly used products. So simplifying the system for those applying for those licenses. But again, and that there might be some way we could agree with the EU that storage could be that suppliers could store a quantity of that perhaps in Northern Ireland itself.
Well, is that not vital? Because otherwise the animal will be dead before you go through the processes envisaged. And
Indeed, there could be a critical issue. Yes.
You mentioned vaccines. It's my understanding that the botulism vaccine is not envisaged to be a part of this or be restricted at all. Is that your understanding?
So the botulism vaccines are usually imported under special license from Australia or South Africa, and we are currently doing that at the minute. Again, that is through the VMD. We are told that there is a workaround that can be put into place for that, but we haven't had any details of that workaround and whether that would be acceptable to the European Union.
And in terms of the reduction of numbers from half to 20%, 15% of potentially impacted medicines available, it has been suggested that the reason for such a significant reduction is twofold. One, that there are licenses in operation, or there are licenses that have been issued for medicines that are not routinely used, and that forms part of the inflated initial figure. And secondly, there are some companies that hold licenses for medicines that have been approved that just simply have not responded. Does that ring true to you?
There was certainly, I think, a delay in some companies responding and taking action. I think we have been informed that the majority of the decrease is either through rerouting of products, so it's not coming from the EU to Great Britain initially to come to Northern Ireland and the Republic of Ireland. It is being rerouted through Ireland, and that's bringing a sense of making it readily available, although perhaps not just as readily available as it could take a little longer in the supply chain to get it into Northern Ireland. And the other thing then is that there are a lot of products that we normally use under certain trade names, but there are alternatives available through EU routes rather than through GB.
And you've been candid enough to say that you have not received a critical medicines list, and you don't confirm that the figure sits at 14, but you don't shy away from the 60 at medium risk category. Is there any, outside of botulism vaccines, are there any particular medicines that you or the Veterinary Association have a significant concern around that has yet to be addressed?
As I say, as I don't have a list, I'm afraid I can't give that detail.
No, not from a therapeutic basis or from experience basis, you know of a product that is routinely used and talked of in your industry. There's no industry chatter, so forget about your confidentiality agreement. I don't want to encroach.
Yeah, no industry chatter, but you know, any vaccine. And I mean, I know that the general industry chatter at the minute is around availability of vaccines, full stop, and that just seems to be a production issue. But you know, I know there was certainly issues around some sheep vaccines in the spring. So there is no chatter. I think the veterinary profession in Northern Ireland, the pharmaceutical salespeople are saying there is no issue, you're still going to get it. There has been some chat about differing pack sizes, that perhaps certain pack sizes would not be authorised, so smaller pack sizes, which would affect smaller farms in Northern Ireland, and that you wouldn't want to buy a pack of, you know, for 500 sheep if you've only got 50. So things like that, that's been the general chat. But I think the salmonella vaccine, we are told that there is no issue with that. That was a serious one because that causes abortion in cattle, and also has public health risks as well.
Okay, thank you, Dr. Dunbar.
Okay, thank you, Claire Hannah.
Thank you very much, Dr. Dunbar. Gavin obviously has touched on some of the specifics, but I wonder, could you, if you haven't already, give us your overall assessment of the working group's progress to mitigate the impact, and comment on what ideally you would see as an interim measure absent the wider EU-UK deal I think we all hope to see.
Yeah, thank you. Yes, I think there has in the last year or so been considerable work done by VMD and DEFRA in relation to the pharmaceutical companies, and I think things have firmed up a lot, because, you know, from 50% of medicines not going to be available to down to 10% is quite a lot. But again, it's just which ones are we not going to get? So some of the solutions, as you say, you know, a veterinary agreement is obviously our that includes veterinary medicines, is obviously the ideal. There could also be maybe something a little simpler around a mutual recognition agreement, which facilitates market access, but that applies to regulated products such as medicines and other supplements, vitamins and things, and might be simpler to negotiate. So that would just be around medicines. But I suppose neither of those are likely to be in place for the end of the grace period on the 31st of December this year, which is sort of less than 8 months away now and creeping ever closer. Rerouting of product via the Republic of Ireland has already been put in place by a number of companies, and that's for EU product. I suppose the GB product is a little more concerning. So we're looking at the development of the special import certification scheme for Northern Ireland, so that it can approve the importation of critical medicines to Northern Ireland from GB and or other places in the world, and that's allowed under EU rules and to import from outside the EU. Other things that have been proposed, but which may not be just as acceptable, is to allow veterinary medicines that are currently used and therefore aligned with EU rules pre-EU exit to continue to be used without batch testing or changes in marketing. This is GB product really, without rebatch testing or changes to marketing authority holder addresses. And any new medicines, though, would need to comply fully. And I suppose really what we would like as any solution here is to future-proof it, so that we're not just talking about current medicines, but that we can access new medicines developed in GB without huge additional cost to Northern Ireland compared to the rest of the UK.
I suppose wherever this lands, the reality is that it would have to be within range of the EU's rules and protocols. But do you have a view on what EU veterinary agreement you think is most suitable for the UK? Mutual recognition or equivalence, including, as you say, the fact that it's not just current medications, it's going to be future stuff as well.
I suppose for the British Veterinary Association position, really, they have produced a position paper on this, on trade deals, and I suppose we've looked at a couple of models, so and come up that could be used. So the New Zealand model, and that relates to equivalence. So mutual recognition of the rules are not exactly the same, but there's mutual recognition that they provide the same protection, and that does not it doesn't fully eliminate physical checks. There still would have to be some physical checks, and there would still have to be some paperwork, but that would be a simplified paperwork. Or there is the Swiss model, in which we align with product of animal origin rules, but there could still be some flexibility built in to allow the UK to require higher standards, say, in animal welfare than would be considered by other EU member states. So yeah, there are some models that we could use, but I think these are perhaps longer term, and it's really having workaround solutions now that are acceptable to the EU, so that our trade can continue.
Thank you very much. Thank you, Chair.
Okay, thank you, Dr. Kirsten Dunbar. That's the end of this panel. We're going to be moving on to panel 2 now. Thank you very much for your time.
Thank you very much indeed. Thank you for your time and for the invitation.
Thank you. If I could call the new witnesses. Thank you. Good afternoon. Okay, good morning, sorry.
He's on number 5.
I do apologise. Good morning. On our hybrid, we have Dr. Lisa Claire Whitten, we have Joel Relland and Dr. Anthony Suarez in the room. So could you introduce yourselves and say who you are? We'll come to you first, Lisa.
Good morning. My name is Lisa Claire Whitten. I'm a research fellow at Queen's University Belfast and also with the Centre for Inclusive Trade Policy at the moment.
Thank you, Lisa. Joel.
Hi, I'm Joel Roland. I'm a research fellow at UK in a Changing Europe.
My name's Anthony Suarez and I am the Director of the Centre for Cross-Border Cooperation.
Thank you very much and thank you for your time today. The Trump administration's approach to trade presents specific challenges for Northern Ireland and the operation of the Windsor Framework. How resilient are the current arrangements for at-risk goods given differences in President Trump's treatment of the EU and UK in their response to US tariffs? And I'll start with you, Joel.
Okay, nice and easy one to start.
Like a challenge.
So I think kind of the main challenge is going to be around whether we see reciprocal tariffs from the EU on US imports. So at the moment they've been suspended for 90 days, but in theory there could be a range of higher tariffs levied on steel, aluminium, soybeans, those kind of goods. And in theory, Northern Ireland would have to apply that external tariff. So it would mean that Northern Irish businesses and consumers would potentially face higher costs on those imports compared to those in GB, which presumably would continue to apply the tariffs that they currently do. So I guess that would probably be the biggest challenge. And then you have questions about, if they're not at risk of moving into the European Union, you can then perhaps claim the difference back, but there's still an administrative compliance cost in terms of having to claim back the difference in the tariff, and also I don't really know to what extent the goods which would be subject to the raised tariff would be considered not at risk. I think from the research I've looked at, it looks that a lot of it would be related to the manufacturing sector, so machinery, stuff for construction, which then I imagine would link into the aluminium and steel tariffs. And to be honest, I'm not a deep enough expert on the mobility of construction goods on the island of Ireland to know the at-risk state of those, but that's where I would say that probably more work is needed to be done to understand the sort of specific level of exposure.
Okay, thank you. And can I come to you, Dr. Whitten? Can you hear us, Lisa?
Yes, I can. Sorry, just a challenge with unmuting myself there. I don't have that much more to add to what Joel has outlined. I guess I would just underline that it's my understanding that the presumption would be when you have safeguards on goods coming in, that they would be presumed at risk. And so you might not see that much opportunity for claiming back the cost of application of tariffs in the event that we had reciprocal tariffs from the EU. So that would be applying to goods entering Northern Ireland from GB that have come from the US. And I guess just in that whole scenario, the risk is about differential arrangements between the UK as a whole and the US and the EU and the US. And so that's what's really the area to be looking at as we go forward in relations with the US at the minute.
And, you know, Joel, you said that, you know, the construction industry, you know, not your area of expertise, but I'm quite interested to say, who should be looking at this impact? Is it the UK government? Is it the EU?
It's probably, I would say would be one for kind of the UK specifically, I guess, to understand, but you would expect that, I think, in the current political atmosphere where there is a desire, to make the Windsor Framework work, but also to deepen UK-EU trade in a kind of unstable geopolitical environment, there's a mutual interest in making this stuff work. So there's definitely an ability to work with colleagues in the European Union, in Ireland as well, to try and understand, what their kind of perspectives are. I would also add there are some differences depending on the way in which the tariff is levied. If the EU tariff is levied using, I can't remember the name of the act right now, but basically an EU instrument which is designed specifically for response to kind of crisis coercion situations, there's potentially difference in the way it's applied in Northern Ireland. So having kind of an open conversation with the EU about how they're intending to implement their tariffs, I think, is important. And then obviously the UK government working with industry to understand the risk that they see themselves exposed to as well.
Okay, thank you.
In that respect, may I just add that I do think the Northern Ireland FSB, Federation for Small Businesses, has appealed to the EU to use an anti-corruption regulation. I can check this because the name is also sort of slipping with me as well, but I believe it's an anti-corruption regulation that is quite new in the EU, which doesn't technically apply under the Windsor Framework in their response to any the US tariffs if and when they do come in after the 90-day period. Again, it's just raising that issue of the importance of clear and ongoing communication between the UK and the EU to strategize their dual responses to the uncertainty coming from the US at this point. Yeah.
Okay, thank you.
I think it's anti-coercion, I think is the name.
Anti-coercion, yeah. That's it. Apology. Close.
Here we are. Thank you very much. Thank you. Gavin Robinson.
Thank you very much, Chair, and good morning to you all. Just picking up on that, I mean, Claire, Lisa. Hi, Lisa. It's nice to see you. You're right, FSB talked about anti-coercion, but they also said that there could be a straight exemption for Northern Ireland from the EU if they so chose, and they raised it 3 weeks ago. I've spoken on it publicly in support. Do you as an academic have any sense whatsoever that there is any actual consideration of this approach within our own UK government? It certainly didn't feature in the joint communication that issued from the Joint Committee. Do you think there is a genuine discussion amongst our government with the EU to protect Northern Ireland?
I think that line of communication is ongoing, is frequent, it's open, and so I would be generally positive about the quality of that conversation to protect Northern Ireland in this context of external trade obligations. I also think that within the UK government, I understand that there is cognizance that as the UK approaches the US in terms of, I know there's ongoing discussion about some sort of arrangement or deal or agreement that would likely be on the level of tariffs rather than any substantive element. The Northern Ireland aspect of that is a point of awareness there. I'm not in the realm of being able to predict how they are going to come to a conclusion in terms of costs and benefits and what they would decide in that realm. But I do think it's a consideration in that broader picture. And I would say this is the most prominent example that we've had so far of what is a dynamic of the Windsor framework and post-Brexit arrangements for Northern Ireland that hasn't perhaps been very prominent, which is to say that it does have implications for Northern Ireland's place as part of the UK in its external relations outside UK-EU relations. We haven't really had the chance to bottom out what that means in different circumstances and case-by-case basis.
Thank you, Joel. Have you any indication that we are being considered fruitfully?
I think the strongest indication is the fact that the two most sort of significant policy issues that are being briefed around this 19th of May summit are an SPS deal and emissions trading. What links those things is they have a potentially significant benefit in terms of facilitating the Windsor framework and GB NI trade. And I think it's no surprise that the EU is more open to flexibility in terms of increased UK access to its market and its systems in those areas that are so integrally linked to Northern Ireland. So I think reading between the lines, they are concerned about making the Windsor framework, both sides concerned about making it work as well as possible. I think tariffs obviously is more difficult because it's such a fast moving picture and no one knows what the White House is going to do from one day to the next, and B, this kind of improvised trade defence policy is new territory for the UK and the EU really. So I think it's inevitably a bit messier and a bit blurrier, but that spirit of trying to make the Windsor framework work, I think, is quite evident.
So Stormont has been back now for 14 full months. That has given us the opportunity to see and for you to indicate to us how effective you think over the last 14 months democratic scrutiny mechanisms have been.
I think the restoration of power sharing has been absolutely vital because it has allowed the Democratic Scrutiny Committee to do its work. And speaking as a researcher who's been looking at this divergence for 3 or 4 years now, the establishment of that scrutiny work has been invaluable, I would say, in terms of both having a record of the EU legislation, which is sort of starting to be applied, and also the level of scrutiny that it allows in terms of the evidence sessions that are being held, hearing from lots of experts, and also the qualified assessments about the impact on trade or other aspects of life in Northern Ireland. So I think that's been a really, really valuable thing. I'd say probably for me, I think the biggest challenge still is that it's a very reactive process. So legislation arrives and you look at it. But the problem with that is, it leaves often quite big gaps when you're going through that scrutiny process. So the GI on craft instruments would be a perfect example of that. A year from kind of the triggering of consent mechanisms to a conclusion being made by the UK government, that's not good for anybody, having a year where you don't know what's going to apply. So I think there is more work to be done in terms of getting ahead of EU legislation and understanding the stuff which is coming down the track. And I would say the loss of the European Scrutiny Committee in the Commons is a significant one there, because they did very good work on that more kind of preemptive scrutiny.
Lord Murphy's review is looking at some of the practical outworkings of these mechanisms, some of the impediments that have come up thus far, a political lack of will on the committee to explore in depth individual issues, and it seems the lack of will seems to be born out of, are you pro-EU or anti-EU? So there's not effective scrutiny on those mechanisms. Assembly members having a very constrained timescale to consider issues in depth, and Assembly members having to take a decision with a brief indication from government, UK government, that they may seek to legislate in the future, which gives no certainty around the prospect or the danger of divergence. Would you agree with those? And do you think there are other issues that have arisen over the last 14 months that need to be considered to improve the effectiveness of democratic scrutiny at Stormont?
In all honesty, I would struggle to provide an opinion on those issues you've described because I'm just not close enough to the way those processes are working within Stormont. But I think, from a slightly more distance perspective, it's clear that there is still a very political element to how it's being used. You just have to look at the divide over people voting for and against applicability motions and to triggering of the Stormont break. So, I guess there is, from that perspective, is it led more by kind of presumptions rather than the evidence? Maybe that points to that a little bit, but I would really struggle to provide more comment than that, I'm afraid.
Lisa?
Yeah, I might comment. The politics, the political aspect, I don't have that much to say on, but I would recognise that the Democratic Scrutiny Committee, while I agree wholeheartedly that it is a positive development in getting it set up and the work that it's been doing has been very valuable from a scrutiny perspective, you also do have to recognise it has an unenviable task. There is a lot of change going on and it's a very demanding position that it has. So I had a look recently. There's been 28 notifications from the UK government about EU acts coming forward that would be in scope of the Stormont break potentially. Of those 9 inquiries that have been held, 17 decisions to not hold an inquiry. And when you look at the inquiry process, you're talking 5-6 weeks for the Democratic Scrutiny Committee to hold an inquiry in which they have to demonstrate engagement across the board with the UK government, with Northern Ireland departments, with business, civil society. So that is a burden of work that ought not to be underestimated. It's also the case that the focus of the scope of the committee is on the operation of the Stormont break, which isn't actually the full scope of Windsor Framework applicable law, and also isn't Windsor Framework applicable law doesn't in itself capture everything that could be of relevance to Northern Ireland from a perspective of UK-EU divergence, the realities of Northern Ireland's position with geographic proximity to Ireland, North-South cooperation, etc. There are other elements that could be relevant for businesses and the society in Northern Ireland that aren't in scope of the Democratic Scrutiny Committee. So it's an exceptionally valuable enterprise effort, development, evolution of the full architecture to overseeing this and scrutinising it, but it also isn't a comprehensive, doesn't have a comprehensive scope or parameters or mandate.
Yeah. Lisa, have you had an opportunity to consider the government's response to the notification of the pulling of the Stormont break and what it says or points to in relation to EU alignment and the government's intentions in that regard?
Yes, so I think the response to the Stormont break that was in relation to chemical regulation on chemical classification, labelling and packaging is indicative of a pattern we're starting to see from this UK government, which is to say that the response is to acknowledge concerns in Northern Ireland, to consult or commit to addressing any issues that would be arising that would lead to a regulatory border between Great Britain and Northern Ireland, a new regulatory border, which is a positive thing in their response, and also to undertake more in-depth analysis, impact assessments of the nature of the change happening at the EU level, and to seek to sort of mitigate concerns coming forward. I would accept that the commitments that we've seen, both in response to the triggering of the storm, also more recently on the decision to add the regulation on geographical indicators for craft and industrial products and also critical raw materials. The government is making commitments along the lines of the awareness of the Northern Ireland position and the intention that Great Britain, in reviewing the relevant regulation there, will make sure that there aren't new barriers arising, but that is a future commitment, and it's contingent on the outcomes of consultations and the development of relevant legislation. So it's an emerging approach where this UK government is much more open to aligning with the EU to avoid new GB-NI frictions and wider UK-EU frictions. But it is one that's going to be an iterative process over time. So there is still a bit of contingency.
I think they're hell-bent on as much alignment as they can get for the entirety of the country, and that's their political raison d'etre. But what you referred to there in response to the Stormont brake being pulled, the government's response to the Stormont brake being pulled, highlights one of the deficits. So the brake was pulled because the CIA, the Chemical Industry Authority, were saying this is £1 billion worth of industry coming to Northern Ireland and it's going to be fundamentally impacted. There's then a greater period of time that the government have an unfettered ability to have discussions, do their analysis, work out their workarounds, do what they need to do, and then they turn around and say there's no problem now. But the Democratic Scrutiny Committee in the Assembly wasn't privy to that information, didn't have the bandwidth to conduct those exercises, and certainly didn't have the product of government's work before they made a decision. It only comes after. That's true too of geographical indicators. So would you accept that that is a deficit in the process? That government's often going way after the fact to try and resolve issues rather than giving the democratically accountable elected members of Stormont the information they need at the time to make the decisions that they should make?
Yes, I would accept that it's a deficit of the process so far. I would also flag that we are still in the early chapters of these processes, and that the Stormont brake, I mean, it's explicit in the way that it's written in the legal text that it's designed to be a last in order for it to be a last resort measure, there has to be able to be prior consultation and engagement with the development of EU legislation much further up the track. And we would all, I'm sure, be aware that EU legislation doesn't happen quickly. And so a requirement for really good, in-depth, specific information about how changes could apply in Northern Ireland and the potential implications. In order to produce that, really you need to be engaging way before an EU Act is published in the official journal, which is when the official sort of democratic scrutiny process initiates. And so I do think it's important to try to see the Stormont brake procedures in the wider context of new mechanisms for Northern Ireland engagement with the architecture of the withdrawal agreements, the Joint Consultative Working Group and Specialised Committee, as well as direct engagement with the European Commission. Now, that does beg other questions about just the capacity and also existing literacy within the Northern Ireland community and awareness and desire to engage with Commission consultations, to request specific briefings on changes. All of that, it is adding burdens to our economy, our society, but at the same time, being able to do that is an opportunity to mitigate us getting to the point where we have, at the CIA giving evidence to say this is going to really impact our economy. So I think it's that.
Thank you. Well, I'll ask you to have reflections on that discussion of frailties of the process, but also very much we know that last Thursday the government decided to add 3 new chapters on critical minerals and on tariffs emerging from Ukraine and Moldova. They did that without seeking an applicability motion from the Northern Ireland Assembly. So despite their claims of engagement and seeking consent and encouraging democratic participation, there was none. What are your reflections on that?
Okay, I'll start with the broader discussion first, where I agree with Lisa Clare's analysis, essentially, which is to say I think the Stormont brake and the applicability motion process were presented initially as, I suppose, obstructive instruments, vetoes, and I think we are now iterating into a form where they are more, I would say, constructive, and rather than being about the blocking of legislation, it's more about a kind of mutual navigation through the weeds of it, and that is a product of the change of government. Fundamentally, there is much more willingness under this Labour government to align with EU legislation, and therefore rather than the default position being to block where you have that risk of divergence. There's more of a thinking about, are there other ways in which we can navigate this challenge? And yeah, I think that's evident in all the responses they've given, where there's been allusion in some form or another to looking at ways to implement some kind of whole UK sort of legislation that would align more or less with what the EU is doing. And I guess on the question of the most recently kind of applied pieces of EU legislation, I mean, I think it's important to bear in mind, obviously, kind of the voices of MLAs are extremely important in this process, but there are kind of, I suppose, three key constituents to the underpinning of the Windsor Framework, being Stormont, Westminster and the EU. And so I think probably the government is also cognizant of how this process is intersecting with its relations with the European Union. And if there is a risk that almost every piece of EU legislation is being rebuffed or kind of the process of implementation delayed, they may be concerned about the blowback into the EU relationship. Because if you're having to kind of mitigate constantly questions around the application of new legislation in Northern Ireland, that is grit in the machine of the wider EU reset, where you're trying to build new trading links, new kind of political, diplomatic links, which you would hope have a benefit for everybody, including Northern Ireland, in the longer term. And so I guess there's possibly some level of, you know, qualified risk assessment prioritisation about, you know, where do you want to, sort of prioritise in the relationship.
On Moldova and Ukraine, it was almost a reiteration of a previous and pre-existing agreement on tariffs, save that we are now incorporated in EU quotas than was the case before. That wasn't the case before. Right, so you could say, somebody could say, they might say that it was inconsequential and it was almost a rollover. Mm-hmm. But is it not right that this UK government is now so firmly in pursuit of wider reset and closer alignment that they were, in these instances, prepared to set aside democratic participation, inclusion and consent of the democratically elected members of the Northern Ireland Assembly who are most impacted by these decisions?
I suppose there is, for a government, always a balanced judgment to be made around that. I mean, this is slightly deviating from the point, but in an extreme example, somewhere like Switzerland, every canton has to approve every piece of legislation which, you know, goes through, and that doesn't make for a quick process. And do you want to go to that level of, you know, direct democracy when you're trying to move things on a kind of diplomatic level with a key partner? That's a judgment for the government to make, really, and I think they have made a judgment.
Really, they don't. Yeah.
Okay, thank you. Sorted Eastwood.
Hi everybody, thank you so much for being here. I feel like I have to declare an interest because I sat on the Democratic Scrutiny Committee, so I know you from being there and giving evidence and stuff. So I suppose just to rewind it back really quickly with Chair's indulgence, I think some of the stuff you've touched on in terms of the actual operation of the committee is really important. Now, I don't want to speak out of turn and my information is old because I'm no longer there, obviously, but I do think that there is a question around capacity and timescales, where I know, and they may have changed this now, but I know that whenever the button was hit for a particular piece of legislation or you were up against a deadline, you had to be called from recess, from whatever it may be, and obviously that has practical difficulties in terms of trying to get hold of people, etc., other, you know, advisors in the background that are supporting the Assembly. So even from just a really practical perspective, it's very, very difficult. There'd been a bit of a school of thought that because we were sort of abutting the end of an EU mandate, that we were at the wrong end of having those consultative conversations before the legislative timetable and programme had already been agreed upon by the EU. Do you think there's any merit in that? And hopefully as time goes forward, as we see fresh elections in the EU, that we'll maybe see a difference in giving Northern Ireland more time to respond to things as and when they come through?
So I think there's definitely the potential for that type of improvement in the system and more sort of bolstering its resilience. We have already had a seminar with Northern Ireland stakeholders that was very well attended, given by the European Commission on the work programme for 2025, where the Commission went through and listed, based on their analysis, those EU acts and proposals, policy revisions and also removals that they feel are relevant to Northern Ireland because they address Windsor Framework applicable law. So that in itself enables, while it's quite a high level approach, it does just run through the different acts, but it allows those initiatives to be flagged to Northern Ireland stakeholders, including business, civic actors, officials. I think there was 160, I would have to check, but I think about 160 attending, to know what's coming forward, and therefore from there, and this is the capacity question on a wider scale for Northern Ireland society, does raise its head around whether or not those businesses, those people in attendance that are aware of these coming changes can then take it forward in terms of engaging directly with the Commission, engaging with the UK government to ask questions about what the plans would be for relevant policy changes on a case-by-case basis. There is an option for Northern Ireland stakeholders, which is broadly defined in this context, to request specific information sessions from the Commission and additional workshops on upcoming legislative changes, where you would have the opportunity to sort of push back or challenge or present information from a Northern Ireland perspective and concerns when it's at that initial proposal stage and still in development. Also, Northern Ireland stakeholders can submit through the European normal consultation processes like Have Your Say initiatives. So there are avenues there to allow for earlier engagement and input from a Northern Ireland perspective, but it does all come back to the capacity question and the ability for businesses and what support there is out there for business, civic society to engage directly, and what support there is for Northern Ireland departments to help facilitate that.
Yeah, I think that's fair, and I know the Executive Office obviously have an operation in Brussels. But do you think, given everything you've just said, that there would be merit in having some sort of a small EU resource or an office based in Northern Ireland to assist people within business, civic society, etc., to navigate that way through?
I think it could make sense, given where we are, given the novelty of the arrangement, given also the fact that we're increasingly seeing that Windsor Framework applicable law is applying in Northern Ireland in a way that it doesn't anywhere else in the EU. And that in itself raises questions about just the partial nature of that, how it works together with UK legislation. So, I mean, I would come from, maybe it's an academic posture, but to maximise the amount of information available and the amount of resources there are out there for interested stakeholders, concerned individuals and organisations to engage. And an EU office in Northern Ireland could help facilitate that further, I think.
Before moving on, can I just bring in Claire?
Yeah, just to follow up on that, and Saoirse has picked up on the Commission having an office, which I think many people would see as a very natural thing, a no-brainer, and I think it was more or less assumed that would be the case, and it was effectively sort of traded away in one of the mad moments of posturing. Obviously there are issues and plenty of scope for scanning, support and capacity building for the Stormont committee, because obviously with a new commission in place and with recent EU elections there's going to be more regulation than they had been dealing with previously. But I suppose the same question to you, Anthony, about the viability or usefulness of a commission office in Belfast, and are you aware of any other interesting mechanisms like observer status? And I will say that from a party political perspective, we're part of the Socialists and Democrats group, and they have now offered us observer status, just acknowledging the completely unique situation of Northern Ireland being, applying to the regulations, but without having full transparency and scrutiny. And do you think there's logic in at least some form of observer status from representatives for our region?
In my view, any channel that Northern Ireland can have in terms of being upstream in terms of the development of policy and legislation within the Commission is absolutely vital, because to be frank, I feel sorry for the Northern Ireland Assembly's Windsor Democratic Scrutiny Framework because of the quantity of work that they have to get through and the time that they are given. And by the time it gets to them, it's too late. You need to be upstream in terms of these things. Lisa referred there to the Commission's presentation of the work programme. This is actually the second time it's happened. They did it for the previous work programme as well, which is a welcome initiative, but it does have that issue around capacity, because I'm coming from a civic society perspective. The organisations that we work with are civic society organisations in Northern Ireland, the Republic of Ireland, and in Great Britain as well. And if you look at the list of directives, legislation, proposed directives, for an organisation coming from the community and voluntary sector, you just look at it and you're in bafflement, because it's really technical stuff, and you're not quite sure does this mean for us. Mm-hmm. And I would point out there is a reliance in terms of that when the Commission presents its work programme to Northern Ireland stakeholders and tries to highlight where it thinks there are directives or proposals that are of that may impact on Northern Ireland, might involve Northern Ireland. There is one directive that we spot that we think has an impact on Northern Ireland that the Commission did not highlight as being an initiative that the Commission thought was applicable to Northern Ireland, and that is the so-called, just the common term is the Defence of Democracy Directive, which we see as directly impacting on North-South cooperation unless it's clarified, unless there's some further better wording of that directive. But it wasn't spotted, it wasn't highlighted by the Commission as something that was of relevance to Northern Ireland. So we can't necessarily always rely on the Commission to be spotting things that they think are of relevance to Northern Ireland or to the Windsor framework. We all have to be attentive to what is coming out of Brussels, but I will also say the same thing applies to legislation coming out of this place, that we also need to be attentive to what's coming out from here, what's coming out from Dublin in areas of their own competence, and how that affects relations on either a north-south or an east-west basis. So it's a huge amount of work to do, and there is a huge capacity issue, but just going back to the original point, the earlier that we get involved, the upstream, as much upstream as possible, the better it will be for Northern Ireland, because by the time a directive is out, it's too late, really.
So to confirm, you definitely see the logic in a Commission presence in Belfast, physical Commission presence in Belfast, and do you see that would be useful for exactly that type of upstream scanning that you're talking about? And can you see potential enhancements of Northern Ireland's presence and operation in Brussels?
I would encourage any way that Northern Ireland stakeholders, Northern Ireland political representatives, MLAs, local authority representatives, in terms of the Committee of the Regions, that they have some kind of status that they can familiarise people in Brussels, all other member states, because this is a process. It is not something that's going to end next week, next month, next year. It's an ongoing process, and people in Brussels. So if there's a Commission office in Belfast that we can also input to, but it's that continual reminding of member states of what the specific circumstances in Northern Ireland are, how things, directives, regulations coming out might impact on Northern Ireland in a way that those who are drawing up that legislation or those directives aren't necessarily aware of unless they have that input from Northern Ireland stakeholders.
Thanks.
May I just...
Go on, yes, you can, Lisa Clare.
Thank you. Just to reiterate really the point on the challenge that there can be when receiving information from the European Commission, just to say, and it's somewhat an observation of internal EU politics, that the arrangements Northern Ireland has for consultation directly with the Commission is very unusual, particularly in the context of EU external relations, to have a sub-state representation directly engaging with Commission on proposals and policies upcoming. And so the consequence of that is that sort of politically, for the Commission officials presenting on the work programme and relevant legislation, they will hold very tightly to an understanding of what is relevant for Northern Ireland that is based on whether or not it amends, replaces applicable EU law under the WINS framework already, or would be perhaps proposed through an Article 13.4 as a new EU Act in scope of the objectives, so that it is quite a narrow definition that the Commission takes of what is Northern Ireland relevant, and which doesn't really account for, in particular, Article 11, but also Article 2, so concerning North-South cooperation and the individual rights and the commitments of the UK government to uphold no diminution requirements of individual rights under the 1998 agreement. So similar to Anthony in and being a shameless geek in this area, you can go through the Commission work programme from this year and identify, I think, quite a number, so around 20, 25 acts that we went through and highlighted that would be likely to be relevant to North-South cooperation based on pre-existing North-South cooperation as it stood just before EU exit. And one prominent example there is a proposal coming back around seasonal adjusted timings. So like British summertime changes, you could have back on the agenda. So those sorts of issues, but also a substantial number in the field of the environment, which obviously has North-South cooperation implications, also transport, also police and judicial cooperation. So I do think there is that broader challenge of where does scrutiny take place for issues in areas that are outside the Windsor Framework applicable law directly, but which would have very clear implications for Northern Ireland because of just the geographic realities of a shared island, and also the nature of cross-border lives that are lived on the island of Ireland. So,
thank you. I'll pick up on some of those later on.
Thank you very much.
I just add two really quick points.
Yeah.
I mean, I think one, there's obviously a role for UCMIS in Brussels, and I think there's still work to be done on exactly what role it plays as a third country representation or mission. Having been used to being inside the institutions, I think still getting to grips with how you gather intelligence from the outside, and I think there are improvements which can be made there. And secondly, there might be something to be learnt from the EEA states, so Iceland, Norway, Liechtenstein, who have something called the EFTA Surveillance Authority, which engages with the Commission from the early stages of legislative development. Obviously, they are much more integrated into the single market, but nevertheless, you know, that surveillance authority has a big, shiny building in Brussels, which does a lot of work and represents their interests, and also raises disputes about is this not applicable, and so some kind of more institutionalised representation is also, I think, something worth thinking about.
Thanks. Thank you. Boutcher.
I'm asking a question on AI in honour of our colleague Dan, who can't be here today, but would be absolutely desperate to ask this. So given everything we've just talked about, I think that's actually quite a good segue into AI, because it's clear that there is the potential for divergence and doing things differently between the UK and the EU. So what are your thoughts on that? And how do you feel that those conversations are being conducted at this stage?
Shall I go?
Anybody?
Okay, so on the AI Act, I think in terms of the impact, I don't foresee a great trade impact, just in the sense that, AI it's an international product, right? Anyone with a digital appliance can procure your thing that you're producing wherever you are, so people are probably going to produce, broadly speaking, to the standards which the EU is demanding. If you're selling something into Northern Ireland, you're probably selling it into Ireland and the rest of the European continent as well. So I don't see much of an issue where things won't be permissible in Northern Ireland, which GB consumers will have. I think the bigger challenge is going to be around compliance and also development/innovation over time. So by compliance, I mean the fact that there are things which now, you have to ensure are taking place in Northern Ireland. So compliance with due diligence obligations, that things are being, an AI chatbot is telling you that it's AI when it's being used, that kind of stuff. That all takes people, it takes resource. Who's going to do that in the UK, sort of from the UK government perspective, to make sure it's happening in Northern Ireland? There's work there, there's admin costs. I think it's comparable to the issue with animal welfare standards as well, which I know has been looked into previously, and there's questions of who's doing what, how are they doing it. So that's just procedure really, which is going to take some work. And then there's the innovative cost, which is, I'm not an AI expert. If you speak to AI experts, what they would say is the UK may be getting a benefit from having moved a bit more slowly on AI than the EU, which went very early, kind of when, ChatGPT has evolved significantly since the AI Act was kind of initially developed. And so it's potentially somewhat inhibitive of more innovative things you could do to develop AI in the future. And the UK, when it develops its legislation, may look to be more encouraging of kind of early stage development than is allowed under the EU Act. And so potentially you attract investment into early stage AI stuff in the UK. It becomes something of a hub. But of course, Northern Ireland would not be able to benefit from that if it's subject to the EU regulations. So you may have, AI investment coming into GB that's not going into AI, into NI, because of the different rule books. And then just to address your final point about how it's being kind of looked at so far, I don't really know. I've seen this kind of statement from the UK government that more scrutiny is needed, but I really don't have any more clarity on where that's going, to be honest.
Okay.
Go
on, Lisa.
The only thing I would briefly add is just to note that the application, or the proposed application of the EU AI Act to Northern Ireland, is the first test case we now have of where we've had an exchange of views, an initial exchange of views in the Joint Committee under Article 13.4, where the EU has proposed adding the whole of the EU AI Act to the Windsor Framework, and the UK government has said that they don't think that's necessary. And so we're now, I believe it's 6 weeks that they now have to exchange information, discuss and find a way forward. If they don't find a way forward, there is a provision in there to allow for remedial measures. If we got to that point, it would be, because of the timeline on these matters, it would be years probably. That's an estimation before we'd ever see anything, and given the development of the industries as well. So it's an interesting test case of where the UK government isn't saying we will just align with EU standards and we want to take this different approach, and therefore they are taking a posture towards of disagreeing with the EU's analysis. I think 3 articles of the EU AI Act do apply under the Windsor Framework because they updated already existing applicable law, and that's very narrow. It's about safety components that use AI in products. But yeah, as Joel said, the application of the full Act would have more substantial regulatory impacts down the line. So it'll be an interesting one to watch.
Okay, just bringing Gavin Robinson.
Would you agree, Lisa, that there seems to be a number of issues here at play? One is that a lot of people talk of AI and don't really understand what they're talking about. And that is true of our government, like the UK government, where they know they're going to have to legislate or regulate in this area, but they're not entirely sure how. So they're at a crossroads. But that there's also a sense that the EU's proposals aren't right, don't fit, and won't work. And then the third and particular aspect, which should be important to this committee, that the advancement into this technological area goes far beyond trade, and would be an expansion of the Windsor Framework in a way that would be, to my mind, unsustainable. And those are 3 issues that I think are at play in this wider discussion on AI.
I think the area that I would particularly have a response to is on the third point there around the expansion of the Windsor Framework. And I do think we are now in the realm of that this is a framework, and it could go multiple ways in terms of its scope and the way that it's used in the broader context of the UK-EU relationship and how close or distant that is. As I say, I think this is a very important first scenario where we have this UK government really advocating for a different approach that is more prioritisation of innovation. And I would agree with what Joel said in that the EU really legislated early, which is perhaps unsurprising, but there is still a whole lot of development in this area to take place, and we haven't really seen, and I think it's hard to do a true impact assessment, which is then difficult from a Northern Ireland perspective, because we're going to have to make assessments before ideally we would want to, because the information isn't there.
Thank you.
So recognise that challenge.
Great, thanks very much. Simon Hall.
Thank you, Chair. I suppose my questions are to Mr. Welland and to Dr. Whitten. The Northern Ireland Secretary, as we know, recently reiterated the government's manifesto commitment to upholding and protecting the UK internal market, and alongside that, obviously, preventing new regulatory barriers between Northern Ireland and the other parts of the UK. I think we'd value your thoughts, please, both of you, on to what extent might the product regulation and metrology bill enable the government to better deliver on that commitment. And I'm relaxed as to who has the first bite of that particular cherry.
Well, you're looking at me, so...
Crack on then.
Okay, product regulation metrology bill. Clearly a potentially very significant instrument for maintaining GB-NI alignment, but there are a lot more unknowns than knowns about it at the moment, I would say. So the first and most obvious question is how wide is its application? The government still hasn't been entirely explicit about this. We know it's the environmental effects of a product that could be in scope, EU legislation that relates to that, but that's very wide. I mean, on an extreme interpretation, the AI Act could fall under that, in that AI uses an enormous amount of energy and it's a product. But on a much more narrow interpretation, it's ionic batteries for electric bikes. So, you know, we don't know exactly how wide it's going to go, and that will affect the extent to which it can be used to, in the government's eyes, mitigate GB-NI divergence. There's then also the question of what the principles are, what the framework is for thinking about how the Act's going to be used if it becomes an Act. Because that's also not been set out very clearly. Is there a threshold at which alignment would be pursued? And what would that threshold be? Would there be explicit things similar to the Stormont break around particular disruption to GB-NI trade which would have to be met? Or is there any other kind of set of principles, perhaps to do with UK-EU trade, which would be looked at? And then the third question is one of resource and delivery, which is that this is, if done on a wide basis, an extremely big piece of work. Basically, you're having to systematically monitor EU legislation across potentially a very wide set of areas. You're having to conduct impact assessments, and where necessary, you're having to implement mirror legislation. That's a large amount of work for any government to do, and who is going to do it, really? Is this going to sit with the business secretary and his department? Is it going to be the NI office? Is it going to be, I don't know, is there going to be sort of every department set out, you need to be monitoring for divergence in your area? Can you trust these departments to do it? Are they going to have the people to do it when we're being told that departmental budgets, headcount is going to be cut? The government has an awful lot of things on its agenda. I seriously question whether this kind of potential alignment could be done on a widespread basis, given the resource challenges that it entails.
Dr. Whitten, just before I bring in, there seems to be a theme emerging that the domestic processes of evaluation, assessment and response are not written for a different period of time, are not potentially fit for purpose to meet the in real time analysis response legislating that we may find ourselves facing. Is that a fair assessment that sort of Westminster PLC, HMG PLC, if you will, should be alert to and giving thought to?
So there is definitely, I think the UK is in a unique position as a third country to the EU in terms of its proximity but lack of institutional relationship. So you have these EEA EFTA countries which are much more economically integrated, and so they have institutional structures which help them manage that. You have a country like Switzerland, which is I would say, partially in the single market. And again, there is an overarching framework agreement to govern that, and they are sort of aligned to EU legislation in those areas. We are in a slightly odd position of looking like we're going to cleave back somewhat, but without any of that real institutional structure for monitoring, analysing, implementing. And that, I think, is a unique function of Brexit and the fact that no country's ever left the European Union before. Could it be done better? Undoubtedly, yes. I think there have been significant failures of scrutiny for the last 5 years, but on the other hand, there would be no perfect system. Even if you had the best intention in the world, I think there's always going to be a gap just because of the enormity of the scale of EU legislation.
Thank you. Dr. Whitten.
I agree with what Joel has outlined, and I would also just observe, if you spend any time in Brussels, it's interesting to note the relative size of third country representations vis-a-vis member state representations, and third country representations tend to be proportionally larger and better resourced than member state representations, which is interesting in itself and is just indicative of the amount of work and resource that additionally goes in when you aren't within the institutions and the ongoing committees and the discussions internal to the EU, but you do have a significant interest in what is said and what comes out of those. And I agree that the UK we are still, in a sense, in early stages of understanding and strengthening and creating architecture sufficient to manage the post-exit relationship, and how to best scrutinise and address the issues that arise. On the product regulation meteorology bill, I would just underline and perhaps draw a parallel actually with the Scottish Government's commitment to align with EU law, in that the provision under this bill allows for voluntary alignment, which is very important and could be really significant from a Northern Ireland perspective to avoid regulatory divergence between Great Britain and Northern Ireland. So that would result, it would mitigate against businesses having to follow two different sets of rules in providing goods to Northern Ireland and the EU and the rest of the UK. But it is also sort of mirror dancing rather than being recognised from the EU side. So it isn't going to mitigate the checks and controls and procedural implications of being outside the EU. What it could very interestingly indicate is almost like a preparation for the type of arrangement that this UK government is pursuing in the relationship with the EU and under the TCA, in that if you did get some sort of formalisation of the mirroring of certain aspects of the EU legislation, that would further mitigate the frictions and the complexities that come with this specific arrangement in Northern Ireland. But that is one of the bigger outstanding questions, and that also leads to SBS arrangements where, while the product meteorology and regulation bill could be significant for avoiding sort of product differences, it doesn't address a lot of the goods that are that we have seen additional frictions on as a consequence of the Windsor Framework, because it excludes agri-food, fertiliser, plants, animal origin, these sorts of things that are a challenge.
I just want to draw, I think, possibly all three of you on this point, just for clarity, which may help this committee when it makes recommendations to government in its report following this inquiry. I think for too many people, Brexit was seen as an event rather than a process to be implemented over a period of time, with different events which would occur, which would need to be responded to after due consideration. I think an awful lot of people then thought that unless the conversation between the UK and the EU was sort of shouty, snarly and finger-jabbing, that was in some way going to be a betrayal of Brexit and an undermining of a democratic decision which we've all sought to adhere to and uphold. I'm guessing here that you would see some considerable merit in order to address issues which have the potential to affect my Northern Ireland colleagues, constituents and businesses on the mainland, tying in 2 points that we've heard from Ms Hannah, the point about having EU representation direct in Belfast, and a beefing up of the UK's representation in the EU as per those countries which we've referenced, who are doing more of the day-to-day, behind-the-scenes conversations of relationship and trust building in order to identify molehills before they become mountains. And neither approach could legitimately be described as a betrayal of the referendum result or seeking to undermine or reverse it through the back door. I don't want to put words in any of your mouths, but is that a fairly safe assessment as to a beneficial landing spot? A yes or no answer will suffice.
Maybe I'll
I wasn't asking you, Mr. Robinson.
I will pick up on your term there before molehills become mountains. That's exactly what needs to happen here. But it goes back to the capacity in terms of doing proper impact assessments, catching things early. And one of the things that I would say in terms of our own engagement with the various mechanisms is under the Windsor framework is that there seems, just because of its nature and the nature of the mechanisms, they're very restricted. There seems to be a kind of an attitude or a process at the moment, hopefully it is improving, but a process where they want to hear evidence of problems. And we don't want to give them evidence of problems. We want to tell them about something that could potentially be a problem and tell them we need to address this so it doesn't become a problem. Yep. And I think that's what one of the big challenges at the moment is, and this is not... This is a challenge not just for the Commission or for the UK or for the joint UK-EU mechanisms. It's separate, it's unilateral as well in terms of Commission and UK government, in terms of being able to really take on things before they are a problem. We don't want to be giving you evidence of a problem, for example, just to give you one. So we do have now the electronic travel authorisation. It has been rolled out now, and it's, I think, the kind of attitude, let's see what the impact is actually going to be on tourism and on cross-border tourism. And we were kind of saying, well, maybe we shouldn't get to the point where we're looking at telling you what the impacts have been, and we can find a solution that means that we're not going to have that problem in the first place. I think that is a big challenge.
Okay, Claire Hannah.
Thank you very much.
Sorry. Sorry.
I think I just wanted I was still trying to find my yes.
Full set.
Just a yes or no answer on the.
I'll contribute a yes.
Thank you. You win the prize for the shortest answer, which is usually the most well received. Mr. Redden.
Uncontroversially, more cooperation is a good thing.
Is that a yes or no?
I can't remember exactly what you said in intricate detail, but broadly speaking, yes. Let's go with that.
Thank you. Thank you, Chairman.
Thank you, Simon.
Thank you. Well, this is all an illustrative example of, I suppose, my concern that while it's really important that all necessary efforts are made to mitigate the impact on business and consumers in Northern Ireland, particularly due to the movement of goods, it does risk overlooking some of the non-trade impacts of Brexit, including the many disruptions and interruptions and impact on north-south issues that I know many of you ably flag and try to mitigate. So I just, I suppose as a starter for 10, aware that we only have a short window while the committee is quorate. I might start with you, Anthony. Can you just address whether or not the necessary conditions have been maintained and protected since the Windsor Framework took effect? And in your answer, you might briefly address that concept and what we mean by that and why it's important.
Yeah, so in terms of maintaining the necessary conditions for North-South cooperation, I'll just go back to that example of the electronic travel authorisation. That has an impact, a direct impact on a formal area of cooperation under the North-South Ministerial Council. That is a formal area of cooperation. It impacts on the operation of a body set up on the Strand 2 of the Good Friday Agreement, Tourism Ireland, which is selling the island of Ireland overseas as a tourism destination. So there is a direct, inevitably there's going to be a direct impact on the operation of a formal area of North-South cooperation, and I think that is particularly worrying. And this is an example, going back to this conversation around impact assessment. We use the term border proofing, which is looking at where policy or legislation is being developed to check on what that policy, what that legislation, what its potential impacts might be on North-South and or East-West cooperation and relations, and to follow really the practice. And we've asked the UK government if it would consider this. The Irish Cabinet handbook has a requirement within it. The policies brought before Irish Cabinet must be checked on their potential impacts on North-South and East-West relations. And it even goes further. It says that policies may not immediately seem to be impacting on North-South cooperation or relations, but you have to look further into it to make sure that what we do here in the Republic government, the Irish government does not impact on Northern Ireland or on all-island cooperation. And I think that is something that really we would ask the UK government to take on that practice as well. And in terms of other areas of North-South cooperation, I know we don't want to go back into history, but unfortunately we are going back into history. During the negotiations for the UK's departure from the EU, there was the mapping exercise undertaken of North-South cooperation, which lists 140 odd areas of North-South cooperation. But the technical notes that were published by both the UK government and the European Commission in 2019, the mapping exercise took place in 2017, but the technical notes were published in 2019. Both the European Commission and the UK government admitted that informal, local, community-led North-South cooperation may not have been included in that mapping exercise. So when Article 11 talks about maintaining the necessary conditions for North-South cooperation, if you haven't captured the huge amount of cooperation that takes place, wasn't in your mapping exercise in the first place, how are you going to maintain the conditions for North-South cooperation if you don't necessarily understand what that cooperation involves in its entirety? And also in terms of the conditions themselves, we have engaged on this issue. The conditions in terms of the mapping exercise were very technical, very legalistic, whereas we understand conditions necessary for North-South and East-West cooperation to be political conditions, the political context that can affect North-South cooperation. I mean, we saw that during the, let's say, the temporary absence of the Strand 1 institutions, which meant then North-South Ministerial Council could not operate, which then affected the operation of the implementation bodies under Strand 2, although to stress, all of those implementation bodies carried on working as they have done for the last, now going into their 26th year, day after day they have been operating. But the political context has an effect on cooperation. The regulatory context has an effect on cooperation. The material context as an access to goods and services, that also has an effect on cooperation. And the community context, the support the communities give to North-South and East-West cooperation is also important. And we don't think that is actually fully understood. And in terms of Article 11 itself, it is very restrictive. It talks about maintaining the necessary conditions for North-South cooperation, but in the application and operation of this protocol, and that's where the problem lies. Because if you look at all the rest of the articles of the protocol, apart from Article 1, Paragraph 3, nothing else really is to do with North-South cooperation. It's all to do with trade, goods, VAT, all sorts of other issues that aren't necessarily about North-South cooperation itself. So that's a major challenge there, is in terms of the restrictive nature of Article 11. And I think something that the Joint Committee really does need to have to address.
Yep, I'm going to come back to you if time allows on other practical implications, but do you think the Joint Committee and others have had sufficient interest and focus on this, and has there been sufficient engagement with civil society organisations and others mapping all this, following all this?
Well, I can tell you that from about 2019, 2020, the Centre itself, and then the ad hoc group for North-South and East-West cooperation that it convenes, and other groups have had been asking for those channels for engagement, and we now do have those channels for engagement in terms of civic society having its channels for engagement with the mechanisms under the Windsor Framework. The specialised committee does meet with Northern Ireland stakeholders, including civic society stakeholders, and we would take part in those meetings and would put forward the views, the issues in relation to North-South cooperation. Obviously, the Windsor Framework, Article 11, is just North-South, not East-West cooperation. So we raise those issues with the specialised committee. Whether they get up to the joint committee, that's a different issue, because it comes back to the restrictive nature of Article 11 and the specialised committee's remit. So it follows its remit. This is not to say that they are not interested, that they don't pay attention to what is being said, and we all sides value that engagement, really do value that engagement, and it is a process that I can see as improving, but I'm not convinced that the challenges facing North-South cooperation are necessarily feeding to the joint committee, and we can just see the joint communiques released after joint committee meetings don't refer to North-South cooperation. The last one did refer to avoidance of a hard border, which I think we're pretty confident that we're not really going to be, and internal market, no reference to North-South cooperation at all.
Do you think there's a reason for that? Is there a reason that you want to share on that? And are you making any recommendations, including to Lord Murphy's review?
Yeah, so in terms of the independent review, we are engaging with the independent review, and we will be putting forth those views in terms of how that process of engagement can be improved. And it's not just, again, repeat, it's not just a process of engagement with the joint mechanisms, the UK and EU joint mechanisms. There also has to be an improvement in terms of the UK side, unilaterally, and the Commission side. They're all parties to this, and they all have a responsibility to living up to the commitments made in the Windsor Framework. So in our engagement with the independent review, we will be putting forth those views again, but it's coming back to that issue of border proofing, looking at things as they're developed in terms of checking to see what this means for our relations on a North-South and an East-West basis, and engaging with stakeholders. And one just further point, in terms of that engagement with the joint mechanisms, EU, UK, when we're talking about North-South cooperation, for instance, and you want to speak to people who are directly involved in North-South cooperation, who can speak from experience in terms of what it's like, what the conditions are for North-South cooperation, we have repeatedly said that it's not enough to talk to Northern Ireland stakeholders. You should be talking in those engagements. The stakeholders, the other end of the North-South cooperation pole, should also be there to be able to express their views, their experience of that North-South cooperation. And I could even see, especially for the business side of things, GB stakeholders being present in those conversations rather than just Northern Ireland businesses, because it's a two-way operation here, and both sides have to be present in order to really reflect the experience of the North-South cooperation, but also in terms of NI, GB and GB to NI trade.
Thank you very much. Lisa Clare, the same, I suppose, set of questions to you, including if you think there are other practical specific impacts or divergences that highlight, I suppose, some of those gaps, and your assessment of maintenance of the necessary conditions and engagement, and recommendations, including to Lord Murphy's investigation or inquiry, or whatever we're calling it, review.
So on necessary conditions, I do agree that there is, within the Windsor Framework, there's an internal contradiction in the objective being to maintain necessary conditions, and then when you sort of scratch the surface of Article 11 and the broader framework, those EU law and policy frameworks that were pre-Brexit shared across the island and facilitating North-South cooperation aren't comprehensively covered in the Windsor Framework. So if it's then Article 11 is sort of internally referenced, it's a referent. It says that, you know, this Protocol Windsor Framework ought to be implemented and applied to maintain necessary conditions, but the necessary conditions that existed prior to Brexit aren't in the scope. And just to put a little bit of substance on that, so I think there was 142 or 152 areas identified in the mapping exercise. Of that, 96 were said to be fully or partially reliant on shared EU law and policy frameworks. That 96 essentially breaks down into three parts. I can't remember exactly, but it's pretty much even thirds, a third of which are fully in scope of the Windsor Framework. So that's addressing cooperation in relation to movement of goods and some elements of transport and energy with a single electricity market. Then a third are partially covered, and as in just a selection of those EU laws that previously facilitated North-South cooperation are in the scope of the framework, others aren't, and then a third aren't covered at all. In the not covered areas, which puts more substance on the challenges where we see these arising, environmental policy is a big area. The EU regulates a lot in the field of the environment, and in that space we have started to see changes because EU law has evolved. And again, the timelines of this do mean that the change isn't immediate. It's more going to be like a opportunity lost sort of scenario across a space of years. And we do have challenges in environmental regulation. Nitrates and Loch Ness has been the dramatic example there. But in that field, we've had a change already to the Water Framework Directive in the EU, which we might see some element of Northern Ireland mirroring for the purpose of managing cross-border elements, but that wouldn't be a requirement. And that's just from some information I've heard from DERA. But there's also more proposals to change directives around the water framework again, groundwater pollution and water quality directives. There's also the soil monitoring and resilience directive that's proposed and is likely to come forward in this mandate of this commission. There's also an amendment to the directive on waste and around managing inland waterways. So all of those things, they're very obviously have implications on a sort of all-island shared biogeographical unit. And for Northern Ireland, the risk is primarily around if the regulation in the south is higher than in the north, you could start to see dumping and degradation and just not what you want to see for a green island.
Yeah. I'm going to come back to your recommendations, but can I just pull out that Loch Ness example as a very, very visible, lurid green, terrifying example of what's going wrong and what could? What do you see as the practical impacts on that?
So, not ducking the question, but I have been involved in a comprehensive report for the OEP on this, on regulatory divergence around nitrates management. And mineral management across the island of Ireland. And so it is due to come out soon, which will address the issue more comprehensively and looks east, west and north, south around what is being done and what the gaps are and discrepancies in regulation. On the very practical, this also feeds into the absence of the institutions for a prolonged period of time. So we didn't have a nitrates strategy updated, and therefore there was, the loss of that regulation, and we bore the consequences. Both north and south, there have been challenges in managing this area of policy, but again, because of Northern Ireland's history and also periods of institutional stasis, what the EU has done historically for the last few decades has been disproportionately important for the management of the environment in Northern Ireland, because in a sense it's sort of pulled Northern Ireland along when it wasn't having a lot of local regulation activity. And so we are in a space now where there's a risk that we fall behind quite quickly if we don't address that. And again, in this space, monitoring is a challenge, and there's awareness across the likes of the Northern Ireland Environment Link and Environmental Justice Northern Ireland of the need to look at this, but it does come back to capacity challenges as well around that. And then also just to say, other areas of North-South cooperation that were previously facilitated and aren't now, police and judicial cooperation is a big area there, and we are currently sort of relying on the TCA framework and also just pre-existing north-south cooperation between PSNI and Garda Síochána. In that area, one of the main sort of potential challenges and things you may want to consider for risk avoidance is around data adequacy, which might seem a bit tangential, but links to other elements where you see if the EU ultimately decide at the end of this year not to renew the data adequacy agreements they have for the UK, that could really call into question the capacity for services north and south to share information of relevance to judicial cooperation, policing, crime prevention, and that then speaks across to also child protection, healthcare cooperation, anything that would involve personal data transfer. Yeah, I could keep going on, but I'll.
Oh, I know you could, and this is. I mean, we're no longer court, and that's. And I appreciate the chair trying to keep us moving, but it does illustrate exactly the point. We I suppose the Brexit, the arrangements around this were frozen in time around a political mood a year ago and an obsession with sausages and feelings and all of this, and literally stewardship of our most vital environmental resource and other issues are just caught in the crossfire of that. So it's a frustration. Do you have any, in our closing seconds, Joelle, do you have anything that it's important to add there?
On the cross-border aspect specifically, no.
Thank you. Thank you very much. Thank you very much.
And I would like to thank Joel, Dr. Anthony Suarez and Dr. Lisa Claire Whitten. If you feel that there's anything you'd like to additionally send us in writing, we would welcome it. Order, order.